Get that boy out of my courtroom before he makes a fool of himself. Judge Harold Collins points his gavel directly at 10-year-old Jamal Washington like a weapon. The packed courtroom gasps. Sarah Washington's face crumples in humiliation. "This is a place for adults, son, not children who clearly don't belong here," Collins sneers, his voice dripping with contempt. Every head turns. Whispers fill the air. The bailiff steps forward to escort Jamal out. But the boy doesn't budge. Instead, Jamal pulls out a thick legal folder and locks eyes with the judge. His voice cuts through the tension like steel. "Your Honor, I'm exactly where I belong, and I have something that's going to change everything." Collins's confident smirk vanishes. The room holds its breath. Have you ever been told you don't belong somewhere, then watched as you proved them devastatingly wrong? 2 months earlier, life looked completely different for the Washington family. Sarah Washington had been the head nurse at Mercy General Hospital for 8 years. Patients loved her gentle touch and sharp medical instincts. Colleagues respected her dedication. She worked double shifts without complaint, always arriving early and staying late to ensure every patient received the best care possible. Her apartment might have been small, but it was filled with warmth. Medical textbooks shared shelf space with her son's homework assignments. Jamal's report cards, all A's, were proudly displayed on the refrigerator alongside Sarah's nursing certifications. Jamal was unlike any 10-year-old you'd ever meet. While other kids played video games, he devoured legal textbooks from the public library. While they watched cartoons, he studied Supreme Court cases. His photographic memory meant he could recite entire constitutional amendments word for word after reading them just once. "Mom, did you know the Civil Rights Act has 17 different sections?" he'd announce over breakfast, casually dropping legal knowledge that would impress law school professors. Sarah would smile and ruffle his hair. "Baby, most kids your age are worried about spelling tests, not civil rights legislation." But Jamal wasn't most kids. He saw the world differently. Every injustice was a puzzle to solve. Every unfair situation was a legal problem with a constitutional solution. When neighborhood kids complained about unfair treatment at school, Jamal would explain their rights under the 14th Amendment. When elderly Mrs. Rodriguez next door worried about her landlord illegally raising rent, Jamal researched tenant protection laws and helped her draft a formal complaint. The walls of his bedroom told the story of a young mind obsessed with justice. Hand-drawn charts connected famous legal cases. Sticky notes covered his mirror with quotes from Thurgood Marshall and Ruth Bader Ginsburg. His backpack always contained at least 3 law books alongside his regular schoolwork. Sarah often wondered where this passion came from. She'd never shown particular interest in law beyond watching the occasional courtroom drama on TV. But watching her son's eyes light up when he discovered a new legal principle made her proud in ways she couldn't fully explain. "One day, I'm going to be a lawyer and help people who can't help themselves," Jamal would declare with the absolute certainty only children possess. Sarah never doubted he would do exactly that. Then everything changed on a Tuesday morning in October. Jamal was at school when Sarah noticed something troubling during her rounds at Mercy General. Dr. Richard Pemberton, the chief of medicine, was prescribing significantly different pain medications for black patients compared to white patients with identical conditions. The disparities weren't subtle, they were systematic and deliberate. When Sarah reviewed the medical charts, the pattern became undeniable. White patients received comprehensive pain management protocols. Black patients received minimal treatment with instructions to tough it out. The medical justifications were flimsy at best, discriminatory at worst. Sarah faced an impossible choice: stay silent and keep her job, or speak up and risk everything. For someone who dedicated her life to healing, there was really no choice at all. She documented everything methodically, then requested a meeting with the hospital administration. She presented her findings professionally, hoping they would investigate and correct the problem quietly. Instead, they fired her 3 days later. The official reason was, failure to follow proper protocols. The real reason was written in the hostile glances and whispered conversations that followed her final shift. She dared to challenge the system, and the system was pushing back. Within a week, Sarah discovered that Mercy General had contacted other hospitals in the area, effectively blacklisting her from nursing positions throughout the city. Her 8 years of exemplary service meant nothing. Her patients' testimonials counted for nothing. Her dedication to medical ethics had made her unemployable. As eviction notices piled up on their kitchen table and job rejection letters filled their mailbox, Sarah watched her son studying legal precedents late into the night. She didn't have the heart to tell him that sometimes the law wasn't enough to protect good people from powerful institutions. But Jamal was already figuring that out on his own, and he was preparing to do something about it. The rejection letters started arriving like a slow, cruel drumbeat. Thank you for your interest in our nursing position. After careful consideration, we have decided to move forward with other candidates who better fit our current needs. Sarah read the same polite rejection over and over. Each one a knife twist in her stomach. 15 applications, 15 rejections, all from hospitals where she'd never even gotten an interview. The nursing director at St. Mary's Hospital was more honest than the others when Sarah called to follow up. Look, Sarah, I'm going to be straight with you. The woman's voice was sympathetic but firm. Word gets around in this industry. Mercy General's chief administrator made some calls. They're saying you're a troublemaker, someone who doesn't follow a chain of command. Fair or not, that's the reputation you're carrying now. Sarah's hands trembled as she hung up the phone. 8 years of perfect performance reviews, countless patient commendations, and medical excellence awards meant nothing against the whisper campaign designed to destroy her career. The pattern was becoming clear. Mercy General wasn't just firing her, they were systematically destroying her ability to work anywhere in the medical field. It was a character assassination disguised as professional networking. Meanwhile, Judge Harold Collins was building his own reputation in family court. Every Tuesday and Thursday, he presided over cases involving employment disputes, custody battles, and civil rights claims. His track record spoke volumes about his priorities. The Rodriguez family had sued their landlord for housing discrimination. Collins dismissed the case, ruling that cultural misunderstandings didn't constitute illegal bias. Marcus Thompson, a black veteran, had filed for disability benefits after being denied coverage that white veterans with identical injuries received automatically. Collins ruled that Thompson hadn't proven sufficient hardship and suggested he find work that accommodated his limitations. LaToya Williams had been passed over for promotion at her accounting firm despite superior qualifications, watching as less experienced white colleagues advanced ahead of her. Collins found her evidence of discrimination circumstantial at best, and noted that sometimes the most qualified person on paper isn't the best fit for leadership. The pattern was unmistakable to anyone paying attention, but few people were watching closely enough to connect the dots. Collins was careful. He used legal language that sounded reasonable on the surface while consistently ruling against black plaintiffs who dared to challenge workplace discrimination. His courtroom had become a place where justice wore a blindfold, not to ensure fairness, but to avoid seeing the systematic bias playing out under its nose. Sarah didn't know about Collins's reputation yet. She was too busy trying to survive. The bills kept multiplying like a hydra. Each one she managed to pay spawned 2 more in its place. Rent, $12,200, due in 5 days. Electric bill, $247, past due with disconnect notice. Jamal's school lunch account, overdrawn by $73. Health insurance, canceled due to non-payment. Car insurance, suspended. Credit card minimum payment, $89, accruing $45 in late fees. Medical bills from Jamal's last checkup, $340. Sarah took whatever work she could find. She cleaned office buildings at night for $12 an hour, her knees aching as she scrubbed floors until 3 a.m. She waited tables at Jimmy's Diner during lunch shifts. forcing smiles while customers complained about cold coffee and slow service, earning minimum wage plus tips that barely covered bus fare home. She picked up weekend shifts at Suds and Bubbles' laundromat, folding other people's clothes while her own son wore the same 3 shirts to school in rotation. The irony wasn't lost on her. She was washing the uniforms of nurses who still had jobs at hospitals that wouldn't hire her. The worst part wasn't the exhaustion that settled into her bones like cement. It wasn't the financial stress that made her stomach churn every time she opened the mailbox. It was watching the light dim in Jamal's eyes as their world slowly collapsed around them. "Mom, why don't you just call Dr. Pemberton and apologize?" Jamal asked one evening as they shared a dinner of instant ramen noodles. Again. His school had started sending home notices about his unpaid lunch fees, and Sarah saw the shame in his face when he had to skip the hot meal line. "Maybe if you tell him you were wrong about the medication thing, he'll help you get your job back." Sarah's heart broke a little more. Her brilliant, justice-minded son was asking her to lie about discrimination to make their problems disappear. The system was teaching him that survival mattered more than truth. "Baby, I wasn't wrong about what I saw. The black patients were being treated differently, and that's not right. Sometimes doing the right thing costs more than we want to pay." "But it's not fair," Jamal said, his voice cracking with frustration. "You helped people. You saved lives. How can they just throw that away?" "Because the people making the decisions care more about protecting their reputation than protecting patients," Sarah replied, pulling him close. "But that doesn't mean we stop fighting for what's right." That night, Jamal lay awake listening to his mother cry quietly in the next room. The thin walls of their apartment couldn't contain the sound of dreams dying. At 10 years old, he understood more about injustice than most adults ever would. And he was beginning to understand something else. The system wasn't broken by accident. It was designed to protect powerful people at the expense of everyone else. But understanding the problem and fixing it were 2 entirely different challenges. 3 weeks later, the eviction notice arrived. Sarah stared at the legal document with numb disbelief. The official letterhead, the formal language, the finality of it all felt like a death sentence. 30 days to vacate the premises. After that, the sheriff would physically remove them from the only home Jamal had ever known. "We could stay with your cousin in Detroit," Sarah suggested weakly, knowing it wasn't really an option. Her cousin's apartment was barely big enough for her own family, and Sarah had no prospects for work in a new city where her reputation hadn't been systematically destroyed yet. Jamal looked up from his homework, a legal research project he'd assigned himself about employment discrimination. The public library had become his second home, a refuge where he could lose himself in case law and constitutional precedents while their world fell apart around them. "Mom, what if there was another way? What if we could prove they were wrong to fire you?" "Honey, I can't afford a lawyer. The public defender's office said employment cases aren't their priority, and private attorneys want retainer fees starting at $5,000. I don't have $5, let alone $5,000. "But what if we didn't need to hire someone?" Jamal's voice carried a strange intensity. "What if we could represent ourselves?" Sarah almost laughed, but something in her son's expression stopped her. There was a focus in his eyes she'd never seen before, a determination that reminded her of herself when she'd first decided to report Dr. Pemberton's discriminatory practices. "Baby, employment law is complicated. It's not something you can just figure out by reading library books." "Actually, Mom, I think it is." Jamal pulled out a notebook filled with his careful handwriting, pages covered with legal citations, case summaries, and detailed analysis that would have impressed law school professors. "I've been researching wrongful termination cases for 3 weeks. Did you know that whistleblower protection laws make it illegal to fire someone for reporting discrimination? And did you know that if we can prove Mercy General contacted other hospitals to prevent you from getting hired, that's called conspiracy and it violates federal anti-retaliation statutes?" Sarah stared at her son in amazement. While she'd been drowning in despair, working multiple jobs just to delay their inevitable financial collapse, he'd been building a legal lifeline one research session at a time. "The filing deadline is next Friday," Jamal continued, his voice growing stronger with each word. "If we don't submit the lawsuit by then, we lose our right to sue forever according to the statute of limitations. But Mom, I think we have a case. I think we can win." For the first time in months, Sarah felt something she'd almost forgotten. Hope. But hope, she was about to learn, could be the most dangerous emotion of all, especially when you're going up against people who have everything to lose and every advantage on their side. The decision came at 2:47 a.m. on a Tuesday night. Sarah had just finished her shift at the laundromat, her back aching from lifting industrial washing machines and her hands raw from folding clothes for 8 straight hours. She walked into their apartment to find Jamal still awake at the kitchen table, surrounded by stacks of library books and legal documents. "Baby, you should be asleep. You have school tomorrow." Jamal looked up with bloodshot eyes but unwavering determination. "Mom, I found something big." He spread 3 case files across the table, like a detective revealing crucial evidence. Each folder was meticulously organized with color-coded tabs and handwritten summaries that demonstrated legal reasoning far beyond his years. "Remember how you said we needed proof that Mercy General blacklisted you? I found the legal precedent that shows exactly how to prove it." His finger traced across a highlighted section of text. "Thompson versus Morrison Industries, 1995. A nurse reported unsafe practices, got fired, then discovered her employer had contacted other hospitals to prevent her from getting hired elsewhere." Sarah's exhaustion evaporated as she leaned in closer. "What happened to her?" "She won. Big time. The court ruled that coordinated blacklisting violates federal anti-retaliation statutes. She got her job back, received full back pay, and the hospital had to pay punitive damages of $250,000. "Jamal, that's amazing research, but how do we prove Mercy General actually called other hospitals?" Her son's eyes lit up with the excitement of someone who just solved an impossible puzzle. "Phone records, Mom. Corporate phone logs are discoverable in civil litigation. If we file the lawsuit, we can subpoena their communications records and prove they coordinated to destroy your career." Sarah stared at the legal documents covering their kitchen table. Her 10-year-old son had taught himself enough employment law to build a compelling case against one of the city's most powerful medical institutions. It should have been impossible, but the evidence was right there in his careful handwriting. "There's more," Jamal continued, pulling out another folder. "I researched the judge who'll hear our case. Harold Collins has been assigned to employment discrimination cases for 3 years. His track record is concerning." Sarah watched as Jamal laid out case after case where Collins had ruled against black plaintiffs, always finding technical reasons to dismiss valid discrimination claims. The pattern was unmistakable once you saw it clearly. "He's not going to want to rule in our favor," Sarah said quietly. "No, he's not. But that's exactly why we have to be perfect. Every legal argument has to be flawless. Every piece of evidence has to be undeniable. We can't give him any excuse to dismiss our case." Sarah looked at her son, really looked at him, for the first time in weeks. While she'd been focusing on immediate survival, working multiple jobs to keep them housed and fed, Jamal had been preparing for war. A legal war against institutions designed to crush people exactly like them. "Baby, are you sure about this? If we file this lawsuit and lose, we'll have spent our last bit of money on filing fees and court costs, and Mercy General might come after us for their legal expenses." Jamal met her gaze with the steady confidence of someone twice his age. "Mom, if we don't file, we lose everything anyway. The eviction notice gives us 3 weeks. After that, we're homeless and you still don't have a job. But if we fight back and win, we get justice and the money to rebuild our lives. And if we fight back and lose, then at least we go down swinging instead of just giving up." Sarah felt something shift inside her chest. For months, she'd been reacting to circumstances beyond her control, scrambling to survive each new crisis as it emerged. But Jamal was offering her something different, a chance to stop running and start fighting. The next morning, Sarah called in sick to her diner shift and accompanied Jamal to the public library. She watched in amazement as her son navigated legal databases like a seasoned attorney, pulling case files and cross-referencing statutes with surgical precision. "The key is the timing," Jamal explained as he printed out forms for filing a civil lawsuit. "We need to document every hospital that rejected you, then subpoena their hiring records to show they had positions available but chose less qualified candidates. That establishes a pattern of coordinated discrimination." "How do you know all this?" "I've been reading 8 hours a day for 3 weeks, Mom. Constitutional law, federal employment statutes, civil procedure rules. It's like learning a new language, but once you understand the grammar, it all starts making sense." Sarah felt a mixture of pride and heartbreak watching her son work. He should have been playing with friends or worrying about math homework, not teaching himself federal litigation procedures because the adults in his life had failed to protect them. That afternoon, they visited the courthouse to file their complaint. The clerk looked skeptical when Sarah explained they were representing themselves, but the paperwork was properly formatted, and the filing fee was paid in crumpled bills Jamal had helped count out 3 times to make sure they had enough. "Ma'am, are you sure you don't want to wait and try to find legal representation?" the clerk asked. "Employment discrimination cases are complex, and you'll be going up against experienced corporate attorneys." Sarah looked down at Jamal, who squeezed her hand encouragingly. "We have all the representation we need." Walking out of the courthouse, Sarah felt something she hadn't experienced in months. Control. They were no longer passive victims of circumstances beyond their influence. They were plaintiffs in a federal lawsuit, armed with evidence and legal precedent, ready to demand justice from a system that had tried to silence them. "What happens next?" Sarah asked as they waited for the bus home. Jamal pulled out a notebook filled with his timeline of legal procedures. "Mercy General has 21 days to respond to our complaint. During that time, we gather more evidence and prepare for depositions. Then we have 90 days of discovery, where we can subpoena documents and interview witnesses under oath. And then? Then we go to trial and prove that discrimination is expensive." Jamal's voice carried a steely determination that reminded Sarah why she'd fallen in love with nursing in the first place, the fierce commitment to fighting for people who couldn't fight for themselves. For the first time since her termination, Sarah went to sleep that night without crying. Tomorrow would bring new challenges, but they would meet them as fighters, not victims. The David and Goliath battle was about to begin. And David had been studying his enemy's weaknesses for weeks. The breakthrough came on a rainy Thursday afternoon in the courthouse's public records room. Jamal sat hunched over a microfilm machine, scrolling through decade-old court cases with methodical precision. His eyes burned from hours of reading faded legal documents, but something was nagging at him about Judge Collins's judicial history. "Jamal, honey, maybe we should focus on our own case," Sarah suggested from across the table. "No, Mom, there's something here. I can feel it." Then he saw it. Thompson versus Morrison Industries, filed March 15, 1995, presided over by Judge Harold Collins. Jamal's heart started racing as he read the details. Patricia Thompson, a black nurse, had been fired after reporting discriminatory treatment of patients. But what happened next made his hands shake with excitement. Judge Collins had ruled in favor of the plaintiff. Not only had he ruled in her favor, he had written a passionate opinion condemning workplace retaliation and racial discrimination. Jamal printed the entire ruling, his mind spinning as he absorbed Collins's own words. "The court finds that no employee should face termination for reporting discriminatory practices," Collins had written. "This court will not tolerate institutional retaliation against healthcare workers who courageously speak truth to power." Mom, you need to see this right now. Sarah hurried over as Jamal spread the pages across the table. What did you find? Judge Collins ruled on a case almost identical to ours in 1995. A black nurse reported discrimination, got fired, then sued for wrongful termination. But here's the thing. He ruled for the nurse. Sarah scanned the document, her eyes widening as she read Collins's own words condemning the exact behavior Mercy General had used against her. This is incredible. He specifically cited federal statutes that make it illegal for employers to blacklist workers who report discrimination. The same statutes that apply to our case. Jamal's voice trembled with excitement. Sarah felt her pulse quicken as the implications became clear. So, if he ruled this way before, he'll have to rule the same way again, or he'll be contradicting his own legal precedent. Judges hate being inconsistent on the record. Jamal pointed to the most damning quote. This court will enforce protection for those who protect others without hesitation or compromise. The words hung in the air like a promise. Judge Collins himself had established legal precedent that would be nearly impossible to ignore without exposing himself to accusations of judicial bias. The legal similarities are identical, Jamal continued. Same industry, same type of discrimination reporting, same pattern of employer retaliation. He can't distinguish our case without applying different standards to similar situations. Sarah stared at the documents. Her 10-year-old son had discovered a legal trap that could force Judge Collins to rule in their favor using his own previous judgment. The key is timing, Jamal said, carefully organizing the Thompson case documents. We don't lead with this discovery. We let him start ruling against us, then we spring the trap by citing his own precedent. As they packed up their research materials, Sarah realized they were no longer just fighting for survival. They were about to expose a sitting judge's inconsistent application of justice, using his own rulings as evidence. It was the kind of legal checkmate that practicing attorneys spent careers trying to achieve. And it was all happening because a 10-year-old boy refused to accept that powerful people couldn't be held accountable. The morning of the hearing arrived with gray skies and bitter cold. Sarah's hands trembled as she adjusted her one-good dress, the same navy blue outfit she'd worn to job interviews that never materialized. Beside her, Jamal clutched his backpack containing their carefully organized legal documents and the explosive Thompson case precedent. They entered courtroom 4B to find Mercy General's legal team already assembled. 3 attorneys in expensive suits huddled around the defendant's table, their briefcases worth more than Sarah's monthly rent. Lead counsel Marcus Whitfield looked like he'd stepped out of a corporate law commercial. Silver hair, confident posture, and the kind of smile that said he'd never lost a case he cared about winning. Judge Collins entered with his usual theatrical flair, black robes flowing as he took his position behind the elevated bench. His eyes swept the courtroom with practiced authority before settling on the plaintiff's table with obvious disdain. This is case number 2024 CV 8847, Washington versus Mercy General Hospital. I see we have... Collins paused, squinting at his paperwork. Pro se representation for the plaintiff? Yes, Your Honor. Sarah stood nervously. I'm representing myself with assistance from my son. Collins's eyebrows shot up. Your son? How old is this child? 10 years old, Your Honor. A ripple of murmurs spread through the gallery. Collins's face darkened with irritation as his gaze fixed on Jamal. Ma'am, this is a federal employment discrimination case, not a school presentation. I suggest you find actual legal representation before we proceed. Your Honor, Sarah's voice gained strength. We've filed all proper paperwork and met every procedural requirement. We're prepared to present our case. Mrs. Washington, employment law is extraordinarily complex. You're facing experienced corporate attorneys who specialize in these matters. This is not a place for amateur hour. Collins gestured dismissively toward Mercy General's legal team. I'm inclined to grant a continuance until you secure appropriate counsel. That's when Jamal stood up. Your Honor, if I may address the court? The room fell silent. Collins stared down at the small figure with a mixture of disbelief and growing annoyance. Young men, children do not address the court in my courtroom. This is not a playground. I understand that, Your Honor, but Federal Rule of Civil Procedure 11 states that any person may represent themselves in federal court. And Family Court Act, Section 249, allows for next friend representation when the individual demonstrates sufficient legal knowledge. Collins's mouth fell open slightly. Several people in the gallery leaned forward. Even Mercy General's attorneys looked surprised. Son, do you have any idea what you just said? Yes, sir. I cited the federal rule that gives us the right to represent ourselves and the state statute that allows me to assist my mother as her next friend's representative, provided I can demonstrate adequate legal understanding. Collins's face began to redden. This is highly irregular. I will not allow this courtroom to become a circus. Your Honor, Jamal continued calmly, we're not asking for special treatment. We're asking for the same rights available to every American citizen under federal civil procedure. The law doesn't have an age requirement for legal knowledge. Marcus Whitfield stood up, sensing an opportunity. Your Honor, plaintiff's attempt to use a child as co-counsel is clearly a publicity stunt designed to generate sympathy. We move to dismiss on grounds of improper representation. Collins nodded approvingly. Mr. Whitfield raises an excellent point. This court will not be manipulated by emotional theatrics. That's when Jamal pulled out his first legal folder. Your Honor, plaintiff objects to defendant's motion to dismiss. Under Kaplan and Drysdale versus the United States, the right to counsel of choice is fundamental, and courts cannot deny representation based solely on age or conventional credentials if the representative demonstrates competence. Collins stared at Jamal in stunned silence. The 10-year-old had just cited a Supreme Court case from memory and applied it correctly to their situation. Furthermore, Jamal continued, the defendant's characterization of our representation as a publicity stunt is unsupported by evidence and inappropriate for judicial proceedings. We're here to present facts and legal arguments, not to generate sympathy. Sarah watched in amazement as her son transformed before her eyes. The nervous boy from breakfast had become a confident legal advocate, speaking with clarity and precision that rivaled the expensive attorneys across the room. Collins recovered his composure and leaned forward menacingly. Son, this is your first and final warning. One more outburst and I'll hold you in contempt of court. Do you understand what that means? Yes, Your Honor. Contempt of court means showing disrespect to the court or its officers. But respectfully presenting legal arguments based on established precedent is not contempt. It's exactly what courts expect from all representatives. The tension in the room was electric. Judge Collins had been challenged by a 10-year-old who not only knew the law but was applying it with surgical precision. Very well, Collins said through gritted teeth. You want to play lawyer? Let's see how well you handle the real thing. Mr. Whitfield, please present your motion to dismiss. Whitfield stood confidently, clearly expecting to steamroll the amateur opposition. Your Honor, plaintiff's complaint fails to state a claim upon which relief can be granted. The allegations are conclusory and lack the specificity required under federal pleading standards. Jamal immediately stood up. Objection, Your Honor. That's not accurate. Collins's eyes flashed dangerously. On what grounds? Defendant mischaracterizes our complaint. We've provided specific dates, named individuals, documented patterns of discriminatory behavior, and cited exact violations of federal employment law. That exceeds the notice pleading standard established in Twombly and Iqbal. The courtroom was dead silent. A 10-year-old had just referenced two of the most important Supreme Court cases on civil procedure, and he'd done it correctly. Collins looked like he'd been slapped. This wasn't supposed to happen. Pro Se plaintiffs were supposed to be easy victories for institutional defendants, not legal challenges that required actual judicial analysis. Motion to dismiss is denied, Collins said reluctantly. We'll proceed to opening statements. As Whitfield sat down, looking decidedly less confident than before, Sarah squeezed her son's hand. They'd won their first battle, but the war was just beginning, and Judge Collins was starting to realize he might have underestimated his opposition. Jamal stood at the plaintiff's table with the poise of someone 3 times his age, organizing his notes with methodical precision. The courtroom remained captivated by what they'd just witnessed, a 10-year-old successfully defending his right to represent his mother. "Your Honor, the plaintiff is ready to present our case," Jamal announced. Collins glared down with barely concealed hostility. "Proceed, counselor," he said with dripping sarcasm. Jamal walked to the center of the courtroom carrying a single folder. "This case is about retaliation. My mother reported illegal discrimination against black patients and was fired 3 days later." He opened his folder and pulled out the first exhibit. Dr. Pemberton's prescription logs show systematic differences in pain management based solely on patient race. White patients received comprehensive treatment. Black patients were told to manage discomfort naturally. Murmurs rippled through the gallery. Collins banged his gavel. "When my mother documented this pattern, she was exercising her legal obligation under federal whistleblower protection statutes. Instead of investigating, Mercy General terminated her employment." Marcus Whitfield looked increasingly uncomfortable as Jamal laid out evidence with professional competence. "But termination was only the beginning," Jamal continued. "Hospital administrators contacted other medical facilities, systematically destroying my mother's ability to find new employment." He presented a chart showing 15 job applications and rejections. 15 qualified applications, 15 rejections without interviews. "The statistical probability of this occurring randomly is less than 0.003%. Collins shifted uncomfortably. The boy was building a compelling case with mathematical precision. "Furthermore, Mercy General hired someone with 3 years less experience and lower performance ratings to replace my mother." Sarah watched in amazement as her son presented their case with impossible confidence. Every document was authenticated. Every argument was precisely cited. "The evidence shows systematic retaliation that violated federal anti-discrimination statutes and state whistleblower protection laws," Jamal concluded. Judge Collins found himself trapped. The legal arguments were sound. The evidence was compelling, but ruling for a black family represented by a 10-year-old would set an uncomfortable precedent. "Mr. Washington, your presentation is adequate. However, employment discrimination requires proof of intentional bias, not statistical anomalies." Jamal smiled slightly. "Your Honor, we have additional evidence that directly addresses intent." "Such as?" "Phone records, corporate communication logs documenting coordination between Mercy General and other hospital hiring managers." Collins felt his stomach drop. "Do you have corporate phone records?" "We subpoenaed them during discovery. Federal procedure allows plaintiffs to request relevant documents." The courtroom buzzed with anticipation. "There's something else, Your Honor," Jamal said, his voice taking on a tone that made everyone lean forward. "We've discovered a relevant precedent case that directly applies to our situation." Collins's eyes narrowed suspiciously. "Which case?" Jamal paused for dramatic effect. "Thompson versus Morrison Industries, decided right here in this courthouse in 1995. Judge Collins's face went completely pale. "Your Honor looks like you might remember that case," Jamal observed innocently. "Should I quote from the court's opinion, or would you prefer to review it during recess?" The judge's hands trembled as he reached for his gavel. He needed time to think, to figure out how to handle what was about to become a legal nightmare. "This court will recess for 30 minutes, Collins announced abruptly. As the judge fled his bench, Sarah grabbed her son's arm. What just happened? Why did he look so scared? Jamal gathered their documents with satisfaction. "Because, Mom, Judge Collins just realized he's about to be held accountable by his own words." Judge Collins returned to his bench 30 minutes later, looking like a man facing his own execution. His usual commanding presence had been replaced by nervous energy as he avoided eye contact with the plaintiff's table. "Court is back in session," he announced, his voice lacking its earlier authority. "Mr. Washington, you mentioned a precedent case. Please elaborate." Jamal stood with quiet confidence, holding a thick manila folder like a weapon. The entire courtroom leaned forward, sensing they were about to witness something extraordinary. "Your Honor, on March 15, 1995, this very court heard Thompson versus Morrison Industries. The case involved Patricia Thompson, a black nurse who was terminated for reporting discriminatory patient treatment practices." Collins's face grew paler with each word. Sarah watched her son with amazement. He was speaking with the precision of a seasoned attorney. "The facts of Thompson are virtually identical to our case," Jamal continued. "A healthcare worker reported racial discrimination, faced immediate termination, then discovered her employer had coordinated with other facilities to prevent her from finding new employment." Marcus Whitfield sensed danger and stood quickly. "Your Honor, plaintiff is mischaracterizing a decades-old case that has no bearing on current circumstances." "Actually, Mr. Whitfield, I have the complete court record right here," Jamal said, opening his folder with theatrical timing. "Would you like me to read directly from the court's opinion?" Collins gripped his gavel with white knuckles. "That won't be necessary." "I think it is necessary, Your Honor, because the legal reasoning from that case establishes binding precedent for exactly our situation." Jamal's voice grew stronger as he pulled out the printed pages. "May I quote from the court's ruling?" "Mr. Washington, I'm familiar with my own—" Collins caught himself, but it was too late. "Your own ruling, Your Honor?" Jamal's eyebrows raised innocently. "So you do remember presiding over Thompson versus Morrison Industries?" The courtroom erupted in whispers. Judge Collins had just admitted he remembered the case, which meant he couldn't claim ignorance of the precedent he'd established. "Yes, I presided over that case," Collins said through gritted teeth. "Excellent. Then you'll remember your exact words from page 12 of the court's opinion." Jamal held up the document and began reading in a clear, carrying voice. Quote, "No employee should face termination for fulfilling their moral and legal obligation to report discriminatory practices. When medical institutions prioritize reputation over patient welfare, they violate not only federal employment law, but the fundamental principles upon which our healthcare system is built." Sarah felt chills run down her spine. Her son was using Judge Collins's own words against him in front of a packed courtroom. "Furthermore," Jamal continued, "you wrote, 'This court will not tolerate institutional retaliation against healthcare workers who courageously speak truth to power. The law exists to protect those who protect others, and this court will enforce that protection without hesitation or compromise.'" Collins looked like he was having a stroke. The words he'd written 29 years ago were now boxing him into a legal corner with no escape. "Your Honor," Jamal said, his voice taking on the tone of a prosecutor closing an airtight case, "in Thompson, you ruled that coordinated employer retaliation violated federal whistleblower protection statutes. You awarded the plaintiff full back pay, punitive damages, and attorney fees." "The circumstances were different," Collins said weakly. "Were they?" Jamal pulled out a comparison chart he'd prepared. "Patricia Thompson, black nurse, reported patient discrimination, fired within days, blacklisted by coordinated employer action. Sarah Washington, black nurse, reported patient discrimination, fired within days, blacklisted by coordinated employer action." The parallels were undeniable. Every person in the courtroom could see that the cases were legally identical. "Your Honor, you also wrote in Thompson, 'Pattern evidence of coordinated blacklisting constitutes conspiracy to violate civil rights, regardless of the employer's claimed justifications.'" Jamal's voice rose with confidence. "We have documented proof that Mercy General contacted 15 other hospitals to prevent my mother from obtaining employment." Collins was trapped. His own precedent demanded he rule in favor of the Washingtons, but doing so would mean admitting he'd been inconsistently applying justice for years. The law doesn't change based on the race of the defendant or the age of the attorney presenting the case, Jamal said, delivering his final blow. Your Honor established clear legal standards in Thompson. Those standards apply equally to our case today. Marcus Whitfield made one desperate attempt to save his client. Your Honor, the plaintiff is a child attempting to manipulate this court with outdated— Mr. Whitfield, Collins interrupted, his voice barely above a whisper. The precedent is clear. The legal reasoning I established in Thompson applies to this case. The courtroom held its breath as Judge Collins stared down at the legal documents that had trapped him in his own contradictions. Based on the evidence presented and the legal precedent established by this court in Thompson v. Morrison Industries— Collins paused, the words catching in his throat like bitter medicine. The court finds in favor of the plaintiff. The words hung in the air like thunder after lightning. The court finds in favor of the plaintiff. For a moment, the courtroom was completely silent. Then chaos erupted. The gallery burst into applause and cheers. Sarah's hands flew to her mouth as tears streamed down her face. Jamal stood perfectly still, letting the magnitude of their victory sink in while the room celebrated around them. Judge Collins banged his gavel repeatedly, but his heart wasn't in it. He'd been outmaneuvered by a 10-year-old using his own legal reasoning, and everyone in the courtroom knew it. "Order! Order in the court!" Collins shouted, but his voice cracked with the weight of his humiliation. Marcus Whitfield slumped in his chair, his expensive suit suddenly looking less impressive. Mercy General's other attorneys shuffled papers frantically, trying to process how they'd just lost a major employment discrimination case to a child. Furthermore, Collins continued, his voice barely audible over the continuing murmurs, the court awards plaintiff full back pay in the amount of $120,000, punitive damages of $200,000, and attorney fees. Sarah gasped. They'd not only won, they'd won big enough to completely rebuild their lives. Additionally, Collins said, each word seeming to cause him physical pain, the court orders Mercy General Hospital to cease all blacklisting activities and to issue a formal letter of recommendation for Ms. Washington to any prospective employer who requests one. Jamal finally allowed himself a small smile. Justice wasn't just theoretical anymore, it was real, it was happening, and it was changing their lives in real time. Your Honor, Jamal said, his voice cutting through the courtroom noise, we also request that the court order sensitivity training for Mercy General's hiring practices to prevent future discrimination. Collins stared down at the boy who had just taught him a lesson about consistency, fairness, and the power of preparation. Granted, the defendant will implement comprehensive anti-discrimination training within 60 days. As the judge prepared to dismiss the court, something unprecedented happened. The people in the gallery began standing one by one, creating a spontaneous standing ovation for the 10-year-old who had just delivered justice against impossible odds. Sarah pulled her son into the tightest hug of his life. Baby, you did it. You actually did it. We did it, Mom, Jamal whispered back. We proved that truth is stronger than power when you know how to use it. Outside the courthouse, word of the victory had already begun spreading. Local news crews arrived to interview the family who had just made legal history. Other families who had been dismissed by Judge Collins approached them, asking if Jamal could help with their cases too. Son, what are you going to do next? A reporter asked, shoving a microphone toward Jamal. I'm going to study harder, he replied, with the same quiet confidence he'd shown in court. There are a lot of people who need help, and I want to make sure I know enough law to help them all. 3 days later, Sarah received her first job offer in months, then another. Word had spread through the medical community that she was the nurse whose son had defeated Mercy General's legal team, and suddenly everyone wanted to hire someone with that kind of principled courage. But the most satisfying moment came 2 weeks after the trial when Dr. Pemberton was quietly asked to resign from Mercy General following an internal investigation into his discriminatory prescribing practices. The hospital couldn't afford to keep him after a 10-year-old had exposed their institutional racism in open court. Judge Collins, meanwhile, found himself under review by the State Judicial Conduct Board. Several other families had come forward with complaints about his inconsistent rulings, all pointing to the Washington case as evidence of his biased judicial behavior. Sarah framed the court judgment and hung it in their new apartment, a bright, spacious place with a separate room where Jamal could spread out all his legal books without cluttering the kitchen table. "Mom," Jamal said one evening as they unpacked boxes in their new home, "do you think Judge Collins learned anything from what happened?" Sarah considered the question carefully. "I think he learned that underestimating people because of their age or race is a dangerous mistake. And I think he learned that his own words have power, whether he remembers writing them or not." "Good," Jamal said, pulling out a new law book he'd bought with his first consulting fee from helping the Rodriguez family with their housing discrimination case. "Maybe next time he'll think twice before dismissing someone who looks different from him." As Sarah watched her son dive into another legal textbook, she realized their victory had been about more than money or jobs. They'd proven that justice was possible when people refused to accept that powerful institutions couldn't be challenged. And they'd proven it using nothing but knowledge, courage, and the unwavering belief that truth would eventually triumph over prejudice. 6 months later, Jamal Washington sat in Harvard Law School's summer program for gifted students, the youngest participant in the program's history. His story had spread far beyond their small courthouse, inspiring young people across the country. The boy who had been told he didn't belong in a courtroom was now fielding scholarship offers from top universities. But Jamal's favorite moments still happened at their neighborhood community center, where he held free legal advice sessions every Saturday morning. "The law belongs to everyone," he would tell families who couldn't afford attorneys, not just people who can afford expensive lawyers. Sarah watched her son help Mrs. Rodriguez with tenant rights, assist the Johnson family with medical debt, and draft complaints for veterans whose benefits had been denied. Each case proved that justice didn't require a law degree. It required knowledge, preparation, and courage. Their victory had ripple effects nobody predicted. Judge Collins quietly retired early. 3 other families successfully sued employers using Jamal's legal strategies. Mercy General implemented comprehensive anti-bias training, becoming a model for hospitals nationwide. Most importantly, their story changed how people thought about power and possibility. If a 10-year-old could defeat institutional discrimination using library books and determination, what excuses did adults have for accepting injustice? "You know what the best part is?" Sarah asked as they walked home from another legal clinic. "What's that, Mom?" "You're still just getting started. Imagine what you'll accomplish with that law degree." Jamal grinned, carrying new cases from people who needed help. "I can't wait to find out." Their story proves something powerful. When people tell you that you're too young or don't belong somewhere, they're afraid of what you might accomplish if you refuse their limitations. Knowledge is power when you have courage to use it. Justice is possible when you're willing to fight for it. Sometimes the smallest voices carry the biggest truths. Jamal didn't just win a legal case. He proved ordinary people can hold powerful institutions accountable when they refuse to be intimidated. What injustice have you witnessed that needs someone to speak up? What would happen if you stopped accepting that's just how things are? Share this story with someone who needs to remember their voice matters. Like if you believe knowledge and courage can overcome any obstacle. Subscribe for more stories about ordinary people achieving extraordinary justice. The world needs more people like Jamal, people who refuse to be told they don't belong. What are you going to do with your power?
At Black Voices Uncut, we don't polish away the pain or water down the message. We tell it like it is because the truth deserves nothing less. If today's story spoke to you, click like, join the conversation in the comments, and subscribe so you'll be here for the next uncut voice.